Welcome to our webinar. It's Wednesday, June 23rd. Joining us at 1:30 in the afternoon for one of Homeline's regular webinars on COVID-19 pandemic rules and tenant landlord law. And thanks for joining us. Joining us today also is Homeline's managing attorney and hotline director, Mike Braw. And we've got some news to share today that a variety of levels on a state and a federal level. So we're going to get to things right away here. Just a reminder about what Homeline is. We're a statewide nonprofit organization. Our main program is a free and confidential tenant hotline. We've advised over 265,000 renters since opening. And we advise folks on our phone right there and also via email on our website in multiple languages. For the past few weeks, we've been doing these webinars fairly regularly with the expectation that there's going to be news about the end of the Minnesota eviction suspension, and there is quite a bit of news this week, and there will be more next week. So for the next couple of weeks, we're going to continue to do weekly webinars, as there'll definitely be updates and news as we head into the end of June and July, and more things change on both a state and a federal level. So I'll put in the chat in just a moment the links to the registration for the next 2 weeks that are coming up on the 30th and on July 7th. And those weeks we're actually going to have two Homeline attorneys, Andrea Palumbo and Rachel Sterling, join us. They've been on previous sessions to give some updates on what's going on, because we're kind of in the thick of things there potentially. All right. Just a reminder, as always, renthelpmn.org 211 for rental assistance. It's going to be increasingly important for folks to know about that. We also, for the past few weeks, have been advertising the Zero Balance project, and for the time being, that's temporarily closed because they received a lot of applications. And if you're a tenant that where your landlord's applied through the Zero Balance project, you should be getting information about completing your portion of the application. You have until the end of July, or sorry, the end of July 2nd to complete your portion. So important for renters that may have been applied for through that program. But for the time being, if you haven't applied through that as a landlord, it's temporarily paused, and Rent Help MN is probably the best bet. So with that, I'm gonna, we did get some questions in advance today, but I think there's a lot of just general information that we're going to be sharing about what's going on a state and federal level with Minnesota's moratorium and legislative updates, as well as some immediate news on the CDC federal moratorium. So we're happy to take more questions throughout the seminar today. With that, I'll hand it over to managing attorney and hotline director Mike Braw, and we'll get to it.
And I'm not sure how much you're truly handing it over today, Eric. We're going to be talking through quite a bit of this together, as a lot of it's brand new stuff. In fact, we didn't even talk about how long I would talk for today when we're prepping for these sessions. We normally estimate how long we think it's going to take to cover sort of the typical topics. And today's speech has largely never been given before, maybe not anywhere, certainly not by me. And so we don't know how long this is going to take, because some of it's a little bit complicated and we want to try to wade through it. But let's start with what we know today. And I stress the word know. So these are the facts on the ground today, and then we'll talk about what's being seriously considered in a second. Right now, what we have is still in Minnesota the eviction moratorium in place through the governor's executive order 20-79, which we've been talking about for well over a year now. Well, not that specific one, but a version of an eviction moratorium. The official end date of that eviction moratorium / peacetime emergency is July 14th. So a few weeks away. As we all know, those 30-day increments have been renewed repeatedly. since last March. So we're up to the 15th renewal. Right now, it feels as though the eviction moratorium is likely to be gone soon, but it isn't yet gone. Today, if a landlord wanted to file an eviction in Minnesota for non-payment of rent, for somebody having an unauthorized occupant, or for a pet, or for somebody smoking in a non-smoking building, they couldn't. They simply, well, they could file the eviction, but it should get dismissed right away. And that's where we've been for several months. 20-79 was passed in August of last year, not passed, it was declared in August of last year. There are exceptions built into that eviction moratorium. Once again, here's what they are. We have the tenant has significantly damaged property on the premises, or they've seriously endangered others on the premises. They've violated a state statute which predates the pandemic by a long time, that prohibits drugs, illegal weapons, prostitution, stolen property being stored in the property. Those exceptions are all still there, as is the family exception, where the landlord or a family member, if they need, that's the word in the executive order, they need to move in, they can ask the tenant to go if that's at the end of their lease, or if they're month to month by giving a month's notice or something like that. But those are the exceptions that we have currently. So that's the current status, the snapshot of what the law is in Minnesota right at this moment. It is the prevalent moratorium. It's the more important moratorium. There is a federal moratorium, and we're going to talk about that in a while. But the federal moratorium routed through the CDC explicitly defers to a state moratorium if it's more protective for renters, which in almost every regard Minnesota's is. So the state moratorium is the one that really has stopped landlords from filing evictions in Minnesota, and will continue to do so until it's gone. That's the first hurdle. They don't even get to the CDC question until they get past this first hurdle of the state moratorium, whether it should be followed or not. Okay, so that is where we are at today. Where will we be in a day or two, or a few days? Hard to know. But the legislature is, as most of you know, currently in what's called a special session. So the legislative session is set statutorily, certain date start, certain date end. The legislature has to stop by that time by law. However, the governor has the power to call a special session if the legislature is not in session, at which point the legislature could adjourn if they wish. The governor can't make them actually do anything, but can call a special session. Because of the peacetime emergency that we have in place, every time the governor renews that for yet another 30 days, the statute that gives the governor the power to have this peacetime emergency, which once again is not just about evictions. The peacetime emergency powers that the governor has are the ones that the governor used to close down restaurants and bars and salons and bowling alleys and then reopen them. You'd have, half the tables full, or maybe all the tables full. All those things were empowered through that original statute that the governor was relying on. And the eviction moratorium is one of those components of that. But the legislature has been in special session since the 14th, so 9 days now that they've been in special session. I'm not sure that they've been actively, appearing in the chambers every minute of that time, or certainly even every day of that time, but they've been moving forward on a lot of different things. There's a lot of components to what they're working on right now, but the eviction moratorium is one of them. And for the first time, we have language that's been introduced that seems like it's a compromise bill agreed upon, sort of, by the Senate, key members of the Senate, key members of the House. And we're going to talk about it and actually go through the language of that proposal, because it feels like it's just a couple of small steps away from actually becoming a law. There is a hearing tomorrow set in both the Minnesota House and the Senate on this housing omnibus bill, which has a lot of other things in it, but the eviction part is certainly there. And then once that's through both chambers, then the governor has the power to sign it. And so by this time next week, we might have less hypothetical version of what the law is going to be and a more concrete version. By all indications, it sounds like the governor is willing to sign what the legislative chambers come up with. But again, what we're going to be talking about today when we're talking about the state rules is what has been publicly shared as the compromise language. And so this feels much firmer than anything else that we've talked about before. We've talked about Senate bills, we've talked about House bills, but both of those are somewhat partisan. The House controlled by a Democrat majority, the Senate controlled by a Republican majority. And it's easy to tell which bill originates in which chamber if you realize who the majority party is in each chamber. And the latest version is one that has pieces of each of the House and the Senate original bills in it. But it does feel like both sides got something. Both sides gave up a lot of somethings. And so it feels like it's much more realistic to see this becoming the law in Minnesota in the very near future. And that's what we're going to walk through in a second. I noticed Eric popped his face up, so he must want to chime in.
Yeah, I was going to just say really quick, this timeline right now is that both the House and the Senate have this language that is going to both the House and the Senate floor tomorrow at some point as early as 10 in the morning. They may debate in one or both bodies for a long time. And then if the same bill gets passed in both the House and the Senate, then it goes to the governor. There's kind of this weird timeline that it could be as soon as the next day or immediately, or depending on when session is set to end, it may give the governor up to 3 days or even 14 days. It seems most likely, given the fact that this is one part of the larger bill that includes funding for affordable housing for the Minnesota Housing Finance Agency, as part of their budget, or it is their budget, that their timeline to get it done before the 30th is pretty strong. So, but that being said, there is the possibility for amendments to happen on this, and there's already been amendments posted for the House debate. So we still can't say that this is 100% the law, but we'll go through it.
Any kind of amendment would have to be agreed upon by both chambers, though, right?
Right, and so it seems unlikely that will happen, but
because they had to move some mountains to get to the point that they're at, as I understand it, and so I'm not sure that either side really wants to try adding different language. But like you said, until it's done, it's not done. Okay, so let's talk about what the language actually says. That we have, again, introduced. This is publicly available information. And we're going to talk about what this joint Senate-House proposal aims to do. It's been called some different things. The off-ramp is probably the most common phrase. I actually think it's an on-ramp back on to eviction business as usual prior to the pandemic. Or phasing in or phasing out, depending on your perspective. The first part of the proposed statute explicitly nullifies the current executive order. So again, 20-79. Once again, if you ever want to look up an executive order, just look up Minnesota executive orders. And then how you sort of chart these is EO is Executive Order 20 is 2020, and it's the 79th order from 2020. There were, I think, over 100 in 2020, and I don't know what we're up to this year, but there's been several as well. Okay, so there are some holdovers, some carryovers from the 2079 that show up in this proposed bill. Under the proposed bill, a landlord can evict for a tenant, once again, seriously endangering others, significant property damage. Once again, we have the 504B 171. That's referring to that statute that I talked about, which is actually from the early 90s. The no drugs, no guns, no prostitution. The family exception, though, no longer appears in this statute. So I have to say, the family exception was, I'm not going to say it's my least favorite, but it was the least understandable from the governor's order of 2079. Not the concept of it, just sort of the execution of it. Family wasn't defined. And the concept of the landlord and or their family member needing to move in wasn't defined. So it's kind of been a contentious issue when it comes up, when landlords have tried to use it, but that doesn't appear in this statute. So the family exception is no longer present. Also, it allows the landlord to file an eviction for non-payment of rent if the tenant is eligible for assistance, but refuses to apply for that assistance or work with the landlord to apply. So that's certainly a new thing. I imagine that won't be that many tenants that refuse to apply, but it's possible. Under the old rule, 2079, the landlord, if they wanted to file an eviction for any of the exception reasons, had to give a 7-day notice or more, depending on what the lease might say. That's no longer required. The 7-day notice is no longer in that picture. So again, that was something of an oddity, the 7-day notice. For instance, on the drug statute, there's not some sort of 7-day notice to go file an eviction that predates the pandemic. So a tenant that had there were discovered drugs in their rental unit actually got slightly more protection under the pandemic than they would have before, even though they were trying to maintain that rule from before. So that 7-day notice would be one change. The non-payment of rent if the tenant is eligible for assistance, but refuses to apply or work with the landlord to apply, is another change. And the family exception is a change, one of the immediate changes. So another immediate change is that the landlord could give a non-renewal or a lease termination for a material breach other than non-payment of rent. Now, what we're talking about here is where the landlord says, I'm not going to renew your lease, or I'm going to give you a notice to vacate for a material violation of the contract. What's a material breach? It's a fair question. There have been a couple different definitions in both versions, both the Senate and the House version. There is a fair amount of case law. So these are decisions that judges have issued in the past that try to explain what a material breach is. I can give you some examples of things that certainly are material breaches. So first of all, it has to say it in the lease or have been a conversation. There are handshake leases throughout Minnesota that does occur, but the vast majority of relationships between landlords and tenants have a written lease. And those leases typically will say some things that landlord cares about that the tenant can't do. They can't have a dog. They aren't allowed to have somebody living there that's not listed on the lease if they're an adult. The tenant can't be smoking in a non-smoking building or drinking in a sober house, whatever kind of sober house it might be set up as. Leases have grown in time. When I started this job in 1996, the average lease was a page, maybe on both sides. That was the most common lease that we'd see. Now, seeing a 10-page lease is not eye-raising at all. Seeing a 50-page lease, that's 50, actually occurs fairly regularly too. Landlords keep adding to leases. They just do. And I'm not sure that I see that stopping anytime soon. I say landlords are adding to leases. Tenants don't really write leases, not residential leases. Landlords write the lease and say, here's the contract. Sometimes the tenant, in very rare instances, can negotiate some small parts of those leases, but in general, the landlord says, this is the contract I'm using, so you'll sign it or else you don't get the rental. And so that's what we'd look at for material breach. Is it in the lease to start with? That's question one. Question two, if there's actually ever a court case about a material breach, or there's a fight about what constitutes a material breach, is a little bit more complicated. Again, we read leases all the time, and some leases are, again, the 50-page leases that we see, they're typed, well, computer generated. Generally, they've been thought through by somebody, and almost certainly by a lawyer or a team of lawyers somewhere. Although the 50-page lease that I'm thinking of mostly is created nationally, and they try to customize it for each state, but it's not perfect for Minnesota. Anyhow, to see a 4 or 5-page handwritten lease, we still see those sometimes. And so sometimes landlords put truly odd things in leases. No fighting, no swearing. We've seen leases where the landlord requires a dress code if the tenant is leaving or arriving home from somewhere. Not making it up. And so let's say somebody does have a dress code in their lease of, that they have to wear red shirts on Thursday or whatever. And they don't wear the right colored shirt on Thursday. Could the landlord evict? I mean, it could be in the lease, right? It's written in the lease. And it says in the lease, if you violate a term of the lease, I can evict you right away for it. And I really care about red shirt Thursday. Could the landlord file an eviction for that? Sure. The landlord could file an eviction for it. The tenant would argue, wait a second, that's not a material violation. My rent's current. I'm not causing any real problems. I wore a pink shirt on Thursday instead of red. That was pretty close. I don't think this is a material violation. And I know people think I'm being facetious, and I'm partially being that, but not really. This is the kind of thing that could be in a lease contract, and a landlord might try to enforce it, and the judge has to decide, is this a material violation? Simply because it's in the lease, that doesn't automatically mean a judge is going to say in an eviction hearing, you know what, tenant, I'm going to make you and your family potentially homeless because you wore a pink shirt on Thursdays. I'm not sure that a judge would do that. I would bet against it. But there's not a lot of case law that says exactly what a material breach is, defining it. And so it's probably going to be a, you know it when you see it sort of argument. I do anticipate a lot more material breach arguments in the very near future, assuming some of these moratoria go away, one or both of them. As we suspect that some landlords will be filing evictions for what they claim is a material breach, but basically because the tenant owes a lot of money and the landlord is tired of waiting and they think that the tenant is gaming the system or something like that. And so they'll simply go file and name one of these material breaches listed in their lease, and then the judge will have to decide. So I'm guessing this will be a much more fertile area for debate in courts between landlord lawyers and tenant lawyers. There is a notice requirement. We're going to talk about that a little bit more, and a safe harbor, we're calling it, for tenants applying for rental assistance, but we'll get into the details more of that in a moment. But let's talk about how I want to present this. And I thought about how to present this statute in a couple different ways. And I opted for going for some key phase in, phase out, again, depending on which language you want to use, happenings. There are several dates listed in the statute. And so let's go ahead and go to the next slide, and we'll talk about this next key date. The first slide was talking about immediate stuff. This one is 15 days after enactment. And we don't know when that will be.
Mike, I was going to jump in and just say immediate under what the bill is right now means that for those sections, it's the day following final enactment, which is again why we were talking earlier about exactly when the House and the Senate can do something, and then when the governor would act. The day after he signs it would be the day of enactment, and so that's the immediate.
Right. So we were a little bit misled or misleading on the slide before, because we said immediate like that's the rule now. It's immediate the day after it's signed by the governor, which of course it has not been. But thank you for pointing that out. Okay, so our next key date is going to be 15 days after enactment. That's, once again, the governor has signed it, right? So 15 days after the enactment. At this point, one key thing happens. The evictions can be filed for material breach of the lease. So remember, I talked about a lease termination non-renewal being fileable immediately after enactment versus 15 days. That's very different from an eviction being filed, which is the court case. An eviction costs the landlord roughly $300 to file. They've been referred to as unlawful detainers for a long time, or UDs. That's kind of the casual phrasing for them. We haven't called them that for over 20 years officially in Minnesota, but people still refer to them that way. But an eviction means a court case. There's a court date, there's a case number assigned. There's a judicial officer that's been assigned to hear the case, or at least be on the calendar that day, depending on where we're talking about in the state. That's the difference, is the landlord could actually go file the court case 15 days after, versus being able to give a notice to vacate for something. This brings up a somewhat interesting conceptual defense, which I hadn't really dug into mentally until just a second ago. So here we go. There's something called a continuing breach of a lease. So a breach is a violation of the lease where there's a rule and the tenant just ignores the rule or violates it. Same thing, a violation or a breach. So there are sort of one-time breaches, right? You have a giant party and, it's really noisy, it bothers all the neighbors, but it's a one-time breach. A continuing breach is something where you've got an unauthorized occupant, the boyfriend or girlfriend or family member moves in, or you bring in a pet, a dog or a cat or something like that, and that's violating the contract. There's no emotional support animal exception. You just bring in the dog because you want a dog. Those are continuing breaches. And if the landlord has been accepting rent, knowing about those continuing breaches, arguably they have waived the right to evict without reasserting something, saying, I'm going to enforce that now. There's a Court of Appeals case on that issue that's from, 15 years ago now, I want to say, that essentially says that. And so it's a possibility that landlords rushing to file an eviction for an unauthorized occupant, but if they've accepted rent knowing about it, might face that defense, a waiver defense. I think that's a real possibility, actually. That, of course, relies on the landlord not only demanding rent, but accepting rent. I think accepting rent makes it a lot stronger case for the tenant, but demanding rent might be an argument that it's sufficient, that the landlord was demanding rent knowing about the ongoing breach. Doesn't mean the landlord can't file an eviction for that. They just have to probably give some type of notice to warn the tenant, maybe up to a full rental period's notice, a full month's notice. Even if it's an open violation of the contract and it's been a continuing violation of the contract, the landlord might need to give a new notice to cure the fact that they have waived that ongoing breach, at least in the eyes of the court. So anyhow, just a thought that jumped in. Like I said, let's go on to the next new deadline that's being proposed. So we're going ahead a month in time. This is 45 days after the enactment. Our last slide was 15 days after the enactment. Now we have lease terminations / non-renewals. Again, not an eviction, lease terminations / non-renewals for a tenant who owes outstanding rent. So that means they're not current, right? I mean, if the rent is due on the 1st of July, the landlord can't go file on the 30th of June if June's rent has been paid, saying, oh, they haven't, they're ineligible for assistance, which is the second prong here, that the tenant is ineligible for assistance, which probably means that they've either applied and been turned down, or just a quick glance at their income perhaps, and it's obvious that they're not eligible for the COVID-19 emergency rental assistance program. We have heard from landlords that swear that tenants are out there that make good money, could afford to pay the rent, and are simply refusing to do so, relying on this eviction moratorium era that we're in, and sort of snubbing their nose at the landlord. And so they may not be eligible for assistance. I don't think that's going to describe the vast majority of tenants that are behind in rent, who probably are eligible for assistance, but they may not know about it. And they haven't applied for that reason. But anyhow, this is what happens 45 days after enactment, is that the landlord can give a lease termination for a tenant who owes rent and is ineligible for assistance. Okay, on to our next deadline. All right, now we go ahead yet another month in time, 75 days after enactment. So once again, we have this staggered system where a landlord's allowed to do specific things. At 45 days, they could give the notice to vacate, non-renewal, whatever you want to phrase it as. 75 days after that, they can actually, or 75 days after enactment, they can file the actual eviction against that same tenant, somebody who owes outstanding rent and is ineligible for assistance. COVID-19 emergency rental assistance programs are actually defined in the statute. They say which ones they are, and they're pretty much the ones that are routed. The giant federal dollars routed through the state are the ones that are statutorily noted. Okay, let's go to our next timed phase out. We go in time yet again another 30 days into the future. So now we're up to 105 days after enactment. The phase out timeline ends. So what we've just been talking about, those rules effectively, or those limitations effectively go away. We're going to talk about one other requirement during the 105 days in a second. But that's when we see those rules that we've been talking about effectively disappear. And so it's back to normal for landlords to be able to file a material breach, probably without any kind of deterrent from the statute, and for filing an eviction for a non-eligible tenant who hasn't qualified for the rental assistance and been ruled ineligible. They could file then. Okay, so let's talk about a couple key safeguards that are in the place for the tenant. So what we've been talking about largely so far is when the eviction courthouse door swings open, for what reasons and at what time for the landlord. But we're going to talk about a couple sort of blanket prohibitions or rules that the landlord has to comply with. Number one is a notice requirement. So those of you that have been watching our regularly scheduled programs have heard us talk about the need for a notice requirement. This was in the House versions of the proposed off ramps. It has not been in the Senate versions, not at least in this type of format. Clearly a compromised agreement, as all of this bill appears to be. So the notice requirement that is in the joint bill, the one that's being actively considered tomorrow, is that during the 105 days that we've just been talking about, if a landlord wants to file an eviction for non-payment of rent, they have to give a 15-day notice. I realize we didn't have the words 15 days written down on here. A 15-day notice. And the notice has to state that the eviction moratorium has ended and that the tenant can be evicted. There's actual language in the statute that says exactly what the landlord is supposed to say. It's supposed to also say the total amount of rent due. And it provides some information about where the tenant can get rental assistance. 211 and Rent Help MN are the two stated entities that the tenant can go to. So some key things about this notice, again, drafted by compromise. The word must appears when it talks about whether the notice needs to be given or not. Must. So that means the notice has to be given. There's no way around that. Must means something statutorily. That means it's a requirement. It's not a should or it'd be nice. It is a must. So the landlord must give a notice for non-payment of rent eviction during the 105 days after enactment. But again, the hallmark of a compromise bill is that there's something that each side gets. The notice section of the statute goes on to talk about what happens if the landlord doesn't give, I guess, a perfect notice, 15-day notice before filing the eviction. The court at that point can use discretion in doing something called staying the eviction if the notice wasn't sufficient. So what is a stay? A stay is a delay in the court case. There's a key difference between a stay and a dismissal. In a stay, the landlord doesn't need to file once again with the court, pay another $300, get a new court number, get a new court date. The stay can simply be a delay in the proceeding where the court says, we're going to keep jurisdiction over this case, but we're going to stay it. And so they could stay the eviction, arguably for 15 days, so the landlord could give a proper notice, I guess, at that point. It's not especially clear how this is going to play out logistically in court battles. I assume there will be lengthy briefs written by lawyers on the landlord side, lawyers on the tenant side, talking about exactly what this section of the statute means. Because to put it generously, there is some ambiguity, borderline conflict in this section of the law. It's just what is. There's another caveat at the bottom of this section that talks about the fact that a landlord substantially complying with this rule, this 15-day notice requirement, should be good enough, not something called strict compliance. So strict compliance is a catchphrase that's been used to describe typically service of process when it comes to court papers in eviction hearings. So there's a very regimented system of what a landlord has to do in order to file an eviction. And then once they filed the eviction, to serve the tenant papers properly. These are very fast cases compared to most other types of legal proceedings in Minnesota. And the tenant has a right to show up and defend themselves, though, but they can't do it unless they're served papers. And so the normal old rule, which we'll see how it plays out when things change, is the landlord files the eviction. Within 14 days, there's a court date guaranteed to the landlord. Once the court has processed the case. And the landlord needs to serve the papers at least 7 days in advance. They sometimes have something like a 7-day window to serve the court papers. So they don't have to actually find the tenant at home. The tenant doesn't win the case by turning off their light when there's a knock on the door and hiding in the quiet. The landlord can try twice, once at night. And if they can't find them, then they're allowed to do something called nail and mail. They put one on the door, put one in the mail. And like I said, there's several steps, there's components to the eviction process, serving the court papers itself, that have to be complied with. And there was a case a couple of years ago that talked about a landlord substantially complying, was the argument. And the court said, yeah, we're going to need strict compliance. You got to comply with all the prongs or it ain't good enough. So this notice requirement says substantial compliance is sufficient. The strict compliance rule isn't the rule. There's an open question as to what would be substantial compliance if they don't simply do what the notice requirement says, because we have must, right? We have must versus substantial compliance. So it's kind of a interesting open question as to how that plays out. Like I said, logistically, I expect fully to see this very issue litigated at some point, although it's pretty easy for a landlord to dodge this issue. They simply give in the notice what they're required to give. In my mind, the key thing about this notice is that the landlord names the amount of rent due. We have heard from landlords and landlord advocates that say that's balderdash or whatever word they might substitute for that. That tenants, of course, know what they owe. Not exactly necessarily true. I mean, if you haven't paid rent since last March, how much do you owe? I mean, it's a fair question. There's rent, there might be late fees. If there's other fees that came due, are there utilities that are outstanding? The tenant might not genuinely know exactly to the penny what they owe. And so this notice does at least require the landlord to state the amount of rent due, which is going to help a lot when the tenant is trying to apply for emergency assistance, or not emergency assistance, but rent help assistance. The one thing I think that almost everybody agrees on is we want ultimately the landlords to get paid what the tenant actually owes. And they're going to have to figure this stuff out anyway. If they're going to file an eviction, they're going to have to name a number. And so it's in the landlord's best interest to give a full accounting of what the tenant owes in hopes that the tenant can use that to go apply for rent help and hopefully get every penny that the landlord is due at that point. So anyhow, the notice requirement is there. It's during the first 105 days. And I noticed some questions coming in, but let's just finish off the last safe harbor point, and then we'll talk CDC, and then we'll get to the questions that come in. Probably makes sense.
I was just going to add, and you sort of did cover it, but the one of the requirements of rent help MN that we've talked about is some sort of documents that talks through the assistance request. So what the past rent due statements, utility bills, and so that sort of stuff. So that's why this is really critically important, is that it'll actually get that information across for folks that haven't gotten it yet. So we'll get to this question in just a moment here and jump to the next slide.
Yep. So another massive piece of protection for tenants is something that we've seen in both the Senate and House versions prior, different details, different dates, but it is that the tenant can't be evicted, and this isn't a misprint, through June 1 of 2022. June 1 of 2, so a full year or 11 months from right now, the landlord can't evict for non-payment of rent if the tenant has applied for this help through rent help and their application is pending. They're kind of given a safe harbor during that time. The tenant is asked to provide proof of the pending application, and if it's possible, to access the reason, if any, for the delay in processing the application. We're not sure how realistic that's going to be for a tenant to be able to produce a reason for delay. The proof of the pending application, much more likely that the tenant can actually provide something to that effect. But showing the reason for the delay in the rent help system might not be feasible. It doesn't require it, it just says if possible. So why is this here? Why is this concept here? That tenants get this safe harbor for a year if they're waiting for the money. Well, to be blunt, rent help hasn't been fast. It just hasn't been. It's a slow they're trying to give out, you know, $700 to $800 million. And they want to do it right. They want to give it to the landlords that are actually entitled to it, not, you know, they don't want to pay a landlord that's already been paid. They want to make sure the tenant actually lives there. They want to make sure that the tenant owes what the landlord claims they owe. There's all sorts of safeguards that rent help has to have in place. And, you know, that's going to be tens of thousands of times that they have to make sure about each one of these safeguards. So it's the kind of thing that takes time. And the legislature has recognized that and said, you know what, we're going to give people time. Once again, the end goal here is to get landlords paid, get tenants current on their rent, so their housing is stable, and get landlords caught up. Landlords who have been unpaid, some of whom since last March. In most cases, it's not that extreme, but in some cases it is. And to try to get those tenant debts settled. And so that's going to take time. And the legislature's more or less said, we're going to give you that time. As long as you're working in good faith to get this done, tenant, we're going to give you this giant safe harbor of time where the landlord can't really do anything eviction wise against you for that time, but you have to be, you know, active in the application process. Now, does that mean that a tenant might wait until the day of enactment and then apply for this, shrewdly stringing along rent help as long as they could without paying their actual rent? Now, I suppose that's possible, but I would submit that I know this because I've talked to them, that there are many tenants out there who, yes, they know they're behind. They don't know the exact number. They literally don't know it. They're not sure. And the communication with the landlord is broken down at this point, fairly unsurprisingly. And the tenant actually has some money. And they might have actually paid the landlord, but there is a lot of dynamics that go into one of these situations where the tenant owes money and they know they don't have the whole amount. So what does that phone call sound like, the tenant thinks? Do I call the landlord up and say, look, I know I owe $5,000 and I got $1,200 right now. I'd like to get somewhat current, but you know, what happens if I pay the $1,200? Do I still owe the $3,800? How does this work logistically exactly? What happens? And it's a nerve-wracking spot for a tenant to be in. And so, especially as the debt mounts up, it builds up, a tenant gets less and less likely to be able to even open the conversation up. Now, that is going to change when the eviction moratoriums go away, because the tenant is going to be compelled to do so if they want to keep their housing. But the landlord will have new footing too. But again, if the landlord wants to get paid, if that's their primary goal, they should be doing everything in their power to help the tenant apply through rent help and encouraging them to do so. And that might, like I said, when the eviction moratoria are gone, that's going to change the negotiating posture between the landlord and the tenant. And so landlords that are convinced that this, tenant that hasn't paid them anything is never going to pay them, that they've just dug in and they're never going to pay, might be very surprised when the eviction moratorium is lifted and the landlord goes to the tenant and says, are you going to apply? Because I don't want to, 45 days, 75, 105 days. I can do something sometime. But if you apply, we might both get settled up here. Your debt might get paid and I might get current on the rent again. So let's start this again. I think there's going to be tens of thousands of renewed conversations between landlords and tenants when the eviction moratoria are both gone. I think that's got to happen if the landlord wants to collect the money. If the landlord simply wants to evict the tenant, that's their only goal, then I guess they can just refuse the money, not agree to help the tenant apply for rent help, and try to chase the tenant out as soon as the courts are open to them. And that's possible, and I think that's going to happen, but I don't think it's, and I hope it doesn't happen in a widespread fashion. We won't know until we see the court doors open, first a little bit with material breaches, and then eventually with non-payment substantially. But hopefully landlords are going to look at this and say, what's my best percentage play for getting all my money back? I mean, is the tenant ever going to be able to pay me that? Probably not. But through rent help, we might be able to be made whole again. And so it's worth it for the landlord to try to reopen the negotiations with the tenant that may have broken down months ago with this new event once the eviction moratoria officially go away. Okay, let's move on to the CDC, the federal moratorium. Okay, so we have talked about the CDC moratorium every time we've given a speech since September of last year when that was first introduced under President Trump. This, once again, is a national moratorium on non-payment of rent evictions. The current version, and we're in time period number 4, the current version ends in a week from today, on June 30th. So will it be renewed? Well, there have been a couple news reports, one from Reuters, I believe it was, one from CNBC that we saw earlier today, that have gotten sources that state that the CDC moratorium will be renewed for another month, so potentially through the end of July. So prior extensions of the CDC moratorium, let's see, the first time period was from September 4th through December 31. Okay. Then there was a weird time where President-elect Biden hadn't taken office yet in late December, but would be by January 20th. So Congress and President Trump sort of punted on the issue and rubber stamped it through the end of January. Then it was renewed through the end of March. Then it was renewed once again through the end of June. So we have had a 1-month renewal before, but that was in the most unusual of the time periods that we're talking about. Well, all time periods are unusual since COVID started, it seems. But that was when there was a president-elect waiting to be sworn in. And so Congress and President Trump decided to simply keep things status quo for that next month until President Biden got into office, and then CDC could decide under President Biden what they wanted to do. So a 1-month renewal is not unprecedented, but what does it mean to do a 1-month renewal versus a 3-month renewal? Hard to know. Maybe what that means is the federal government is aware that the challenges that Rent Help Minnesota have been facing to get all this money out the door to Minnesota landlords are not just challenges in Minnesota. These are challenges in every state in the country. How do you get this done efficiently, effectively, fairly? And so maybe the thinking is that just another month's time would give the space needed to get landlords around the country paid. And just to be clear, many other states do not have any kind of state moratorium in place. And so the CDC eviction moratorium means a lot more in those states than it potentially does here in Minnesota, where we may have an off-ramp developed by then. And we're still in our current time period where through July 14th, we have an eviction moratorium in place unless and until it's replaced by something legislatively. The CDC moratorium has been attacked nearly a dozen times now in courts around the country, federal courts exclusively. The most meaningful court decision was from the DC Circuit Court of Appeals, where an injunction that had been granted stopping this eviction moratorium from continuing had been granted by the district court judge. But then the 3-judge Court of Appeals panel said, no, we're going to issue a stay. The government is likely to prevail in this case. The case was appealed to the US Supreme Court by a landlord group, Alabama Association of Realtors. They're the named plaintiff on this case. And last I heard, the CDC was to submit their reply. The Supreme Court could take it up, and they can take it up in a fast track manner if they wish. To my knowledge, that has not been done yet. And I don't know, maybe that's why they're doing a 1-month extension. Maybe they think that the Supreme Court is less likely to take it up if they think it's only going to last for another month. Who knows? That's a cynical view that just popped into my head, but I guess that's where lawyers' minds go sometimes. Once again, the CDC moratorium only prevents non-payment of rent evictions. That's it. In Minnesota, a landlord currently can't evict for the family member moving in or for the pet. That might change very soon. But the CDC is literally just for non-payment cases. And as mentioned several times already, it does defer to a local protection, whether it's a state or a county or a city. There are cities throughout the United States that have enacted their own eviction protection, some of which go several months. I think there's a few around the country that go through the end of the calendar year, but I didn't do much research on that specific question in order for today's presentation. Okay, I think that's the main stuff I wanted to get to before we get to questions, Eric. What do you think? Is there anything I should have talked about, but I haven't yet?
No, I think that covers most of the details for right now. I did see, maybe you commented on this, I was checking something else, that the plaintiffs, maybe you said this right, the plaintiffs in the Alabama case did just send this today, a renewed request to the Supreme Court to vacate the stay.
I don't know what a renewed request means. I don't work in appellate Supreme Court levels. I know that they've already asked for this, so I don't know if they just re-ask or how that works. But
they appeared to re-ask because there is official word from that shows that the CDC has asked for this now.
That both sides want it.
No, it has asked for
the extension.
For the extension, yeah.
I see.
So
I guess that's a new fact. So it makes some sense that they'd say, hey, Supreme Court, you might have thought this was all going to be over on June 30th, but they're going to go another month. So you should know that new fact. So I guess that makes some sense. Yeah.
So maybe I'll jump back to the couple slides that this one question was about.
Sure, go ahead.
So this slide says evictions are allowed during the 105 days after the governor signs the new bill. However, I thought earlier slides said that there is no option for filing evictions on non-payment. Do you mean non-payment of rent evictions, which are available to landlords after 45 days through 105 days?
So if we go back a couple slides from there, we see on actually our first.
Yeah. Non-payment if the tenant is eligible and refuses.
But refuses to apply or work with the landlord to apply. So that's our first time when a landlord can file an eviction for non-payment of rent. And that could be immediately after enactment. The landlord would still need to give the 15-day notice. So because it's a non-payment of rent eviction. Let's say the CDC does not renew and the state off-ramp is granted and it starts in July 1. We'll just use July 1 as our enactment date. The landlord at that point could give a 15-day notice of non-payment for a tenant who says, I don't care what you think, I'm not going to apply for assistance. I don't believe in the government, or whatever their theory is. The landlord, on July 16th, in theory, could file that eviction for non-payment of rent. So look, whoever wrote that question, it was anonymous. I certainly don't fault you for asking a clarifying question. This is somewhat complicated stuff. And what we'll be trying to do not somewhat complicated, this is complicated stuff and it's important stuff. But what we're going to be trying to do is we're planning to be giving weekly speeches for the foreseeable future is to say, here's what the rules are right now. Here's what the rules are going to be next week or in 30 days. We're going to try to keep you as apprised as we can, along with how courts are interpreting this, because that's the other component here. Courts are the ones that decide all this stuff. I mean, the legislature gets to write whatever they want. And I mentioned the fact that the notice issue is sort of fraught with multiple legitimate interpretations. And so we're going to be trying to say exactly what we think the rules are, when they activate, what the next new rule that comes into play will be. But yeah, this is complicated stuff and I don't fault anybody for asking that question because it made sense to ask it.
All right, so a couple that came in the chat and in advance. What does application for assistance include? Is it just Rent Help MN? county EA, EGA, private nonprofits. And that, I think, is referring to the way that the bill as drafted refers to the COVID-19 emergency rental assistance program and pending application for assistance through an emergency rental application program. And it defines it right there as money that comes from the Consolidated Appropriations Act 2021, which I think that's the one that passed when Trump was still in office. And then, well, that and then the American Rescue Plan Act 2021, which is effectively the funding that is adding up to around 670 million in Minnesota.
Yeah. So yeah, there's two main pieces of money or pots of money that we're talking about. The one from the CARES Act is not included anymore because I don't think that there's any money available from that. But this money is from, yeah, I think you're right. I think one was from the Trump administration, one was from the Biden administration as well. But they are specifically named in the statute. Yeah.
Yeah, and it doesn't include the CARES Act because my understanding is that there's actually some counties and states that still have CARES Act money.
Oh,
yeah. So yeah, it defines that in the bill as these two laws, federal laws.
It's a sensible question. That's why they included it in the statute, because they knew people would ask it.
Okay, there was a question in the chat about from a landlord, and my tenants have several continuing breaches since the contract started. I have a non-waiver clause in my lease. It was financially too difficult for me to not accept rent from my tenants these past months. Should I not move forward with an eviction until I re-notify them a whole rental period out that they are in breach?
So yeah, very knowledgeable question. There's a lot of insight built into that question. So I'm not a landlord attorney. I'm an attorney and I represent renters and advise renters. That's what I do. If I were a landlord attorney and a tenant came to me with that, I would say there's a chance you could lose this case because you've been accepting rent knowing about the ongoing breach. And so my conservative advice would be, yeah, give a notice, because then it gives the tenant a chance to do a couple different things. Maybe they can correct the situation, have the family member move out or something like that. Or they can decide to move out on their own prior to the eviction being filed. But what you're talking about, having the non-waiver language in your lease, might not be enough to win the knowingly accepting rent about the continuing breach. A tenant advocate would certainly make that argument, and I think there's a chance that they would succeed with that. So my conservative advice, if I were a landlord lawyer, would be, yeah, give the notice anyway. It's only going to delay things 30 more days. I assume that they've been paying rent. That's why you've been accepting the rent. So it's not like you're out the more money. It would just make your case stronger if you had to file the eviction eventually.
But that is that advice only after this becomes law?
Yeah. That's not the advice right now. That's when it becomes a law. Correct. I would wait until we enter at least the immediate rules section after enactment before I'd be bothering with this sort of thing.
Another question from the chat is that the bill specifies the amount of rent due. So this is in the notice section line 31.2. The notice has to include the total amount of rent past due. Does that mean the landlord can omit late fees, utilities, other non-rent charges?
So Eric just cited a specific portion of the statute, and I just scrolled to it as well. Look, we're not using this stuff to advise people every day, so I certainly don't have it all memorized, although I've looked at it more times than I care to to have done already. But no, it does say the total amount of rent past due. It does not include late fees, utilities, or other non-rent charges. So would a landlord be able to include everything else? Sure. It's not a limiting statement. The notice requires that the landlord state the total amount of rent past due. It does not say the landlord can only include the amount of rent past due. They can't list anything else. I would strongly encourage a landlord to list everything that's due if the landlord's goal, once again, is to get paid. If the landlord's goal is to get paid in full, they should list it all. If they want to try to trick the tenant and win an eviction, maybe they don't list everything else. But a landlord that wants to win an eviction versus getting paid potentially, for a year worth of rent, they're not going to be in the landlord business long. I can't believe that most landlords would rather win an eviction than get paid in full in this situation, at least most times right now.
Yeah, and I was referring to an earlier version of when it hadn't been passed by the committees. I just put in the chat again a link to the current version that's going to be in front of the House floor tomorrow, and this is line 31.13 of that. And the next line talks about that the notice has to say a tenant should visit Rent Help MN or call 211. So those programs do say that there are eligible expenses beyond rent. So that's really the whole purpose, is that you get everything paid.
Yeah, it's one of the biggest changes we would like to make in the statute if we had the power to snap our fingers and fix it. We actually think that landlords should be in favor of this as well, but so far that doesn't look like that's likely to happen.
All right, a couple more that have come in here. If a tenant applies for Rent Help MN after they've received an eviction notice, will they receive the safe harbor protection? What if they apply for Rent Help MN during the 7-day period to pay and stay? If granted by a judge, would they receive safe harbor protection?
It's a great question, an anonymous asker, and I'm looking at the actual language of the statute once again. And what it says is that I'm going to read some key parts of it. Notwithstanding any law to the contrary, the filing of an eviction action or proceeding with an eviction action for non-payment of rent is prohibited. And that's through June 1 of 2022. And that's if the tenant has applied for the rental assistance. So the key parts that I'm zeroing in on here are this phrase, the filing of an eviction, and I don't think we have the exact language here. It's the filing of an eviction action or proceeding with an eviction action or proceeding. So the filing, we know what that is, right? That's where the landlord goes to the courthouse, or whether they do it electronically or in person, and they file the case. That's the filing. How is that different from proceeding? Because how you do statutory analysis is you have to assume that every word means something, that the legislature meant something by each and every word there. So when it says the filing of an eviction action or proceeding with an eviction action, that must mean that or proceeding means something other than the filing of an eviction action. So again, we don't have any precedents interpreting what this statute means because it's a theoretical statute at this point. But if I'm a tenant lawyer arguing right now, I'm going to say, well, wait a second, they applied, judge. I know that the landlord filed the eviction the other day and the tenant hadn't applied before they filed, but the tenant has since applied. So we need to not proceed, as this statute instructs, with the eviction action. What will happen to the eviction case? Arguably, it could get dismissed, it could get stayed, it could get postponed. I mean, they can come up with a lot of different words for it. But I think that if the tenant applies midway through the eviction process, that in theory, it stops, not even in theory, I think the words on the page stop the eviction from proceeding. Once again, we have to assume that every word in the statute is intentional and it means something. So the two words or proceeding means something different than filing. And I think that that's the argument I'd make. And I think I should win on that if I'm a tenant. Solid question though. These are really good questions.
Yeah, and that language is on 31.24 to 25. If you're
those numbers
along.
have moved around from the version I have in front of me.
Yeah, I'm using the link that was sent, which is the current bill.
Yeah.
Not the bill that was seen in front of a committee. So the current bill that the House will be looking at is at that link in the chat.
Sure.
Okay. Anonymous question. Can you clarify when landlords will be able to give notice to vacate or terminate an expired lease that is month to month? I think I missed something.
Well, let's go back in our slides once again let's see here. We have the 105-day rule. Certainly, a landlord can give a notice to vacate or a non-renewal. Once the 105 days are done, that's when all those restraints more or less get lifted. The only thing we have left after that is the can't evict for non-payment of rent as long as the tenant has applied. So that one is the clear, sure answer for almost all the other types of questions you're asking. The other ones, the other timeframes that we were talking about, the immediately, the 15 days, the 45 days, the 75 days, talk about various things that have to occur first. If the tenant is applied but they're ineligible, if they are, if there's a material breach, so they hinge on something else. But after the 105 days, then a landlord could give business as usual a standard notice to vacate non-renewal under the statute that we're talking about. I think there's a follow-up question asking, where do I think the number 105 comes from? Yeah. Well, first of all, they went with 15 days being an important starting increment, and then everything else is 30 days after that. So I don't think they really picked 105 or 45. It was 30 days later, 30 days later, 30 days later. So that seems to be where they came up with the 105.
All right. Well, and 105 is in there a couple times or a few times, like
it is.
Yeah, but where they came up with it, yeah, good question for the legislature. Okay, a question from Ben. What is your perspective on the fact that individuals no longer residing in a unit, for whatever reason, are ineligible to receive emergency rental assistance? Is that a significant issue you expect to see in court?
Well, we don't expect to see it in an eviction court, right? Because the tenant's no longer there. An eviction is just about possession of the rental unit. That's all the landlord can really win if they file an eviction. So it's not going to be an eviction case argument. Where we would see that argument is if the landlord sues in small claims court for up to $15,000, or district court if they want to sue for more money than that. But I can say that portion of the statute, and what I'm talking about here is not the state law, but the federal law that authorized the payment of this money, is not especially surprising, looking back at other types of financial assistance that have been available to tenants historically, like emergency assistance, which is a federally sourced, routed through local entities. But that type of emergency assistance is not available for tenants to pay past debts. It's to keep tenants current in their home, to stabilize their housing, is the theory behind those types of emergency type payment. And look, I mean, the government knows that landlords have been stopped from filing evictions. So have tenants left their places voluntarily? Sure. But the money is supposed to go to help stabilize homes, to make sure people don't end up homeless and overly penalized because they lost their job because of COVID, is the theory behind this. So it's not a surprise to me that it's a requirement that it has to be for the tenant's current place. And it's another, and maybe the single strongest incentive for a landlord to not try to force a tenant out as soon as they're absolutely possibly able to do so, because financially it may very well not be in their best interest. Once again, we haven't really walked through that eventuality. But let's say a landlord does go file an eviction against a tenant who owes a bunch of money, and they're just not interested in waiting for the tenant to figure out how to use rent help. And so they go and file and chase the tenant out as soon as they're able. When are they ever going to get the money? When is the landlord going to get the money? Well, they're going to get it in a couple of different ways. They can ask the tenant. If the tenant comes into money and just has a lot of it laying around, they could pay. Unlikely, but it could happen. The landlord could turn it over to a collection agency, or even file in court. I think there's a real chance that if the tenant owes a lot of money, they're going to look into filing a bankruptcy, at which point it's very unlikely that the landlord will ever see a penny of that money. I mean, it'll have a huge impact on the tenant's credit, so it'll, negatively impact the tenant, but that doesn't put money in the landlord's pocket. The landlord could try to garnish wages if they win the court case. Again, if it's enough money, tenants are going to look into bankruptcies, or the tenant just doesn't have the money. You get a judgment against a tenant, or you send the collection agency against somebody who just doesn't have any money or enough money to be able to pay off much beyond the minimum wage level. You're not going to collect that money very quickly if you're going to collect it at all. So this is going to be something that a lot of landlords that have never had to deal with this situation, chasing a tenant that has left for money, are going to have to confront. But winning an eviction doesn't win money for landlords. If they really want the money, again, their best percentage play is almost certainly going to be to help the tenant apply for rent help and see if they're eligible. And if they are, the landlord might get paid everything back, which I'm guessing most landlords, they might be really angry with their tenant because they think they've been betrayed over this time. They think the tenant had the money and didn't pay it, or whatever they think has been going on. But if they want to get paid, probably their single best shot is through rent help.
Right. Okay, now a question from Sandra. So to clarify, are you saying that 105 days after the bill is signed, if it's signed like this, then it is business as usual if the lease is month to month and the landlord can choose to give the appropriate notice for the tenant to vacate? For instance, if the landlord needs the unit for a family member.
That seems to be the rule. Yeah, and you wouldn't need a family member reason or something like that. I mean, the normal rule, normal times, is if a lease is over, that either side can end the contract, and as long as proper notice is given. And so that is, yeah, I think that the answer is yes to that question. Let's see, Eric just sent me a quick message here as well. It's something that we haven't talked about today, nor have we talked about it much in the last few months. And that is, we did refer to the CARES Act earlier, where we talked about the money that was available through the CARES Act. But the CARES Act also had an eviction prohibition for buildings that were covered by the CARES Act. And that eviction prohibition ended in late July of last year, so in 2020. However, there was after the eviction prohibition requirement that the landlord give 30 days notice to the tenant in order to file an eviction for non-payment of rent. Now, again, we haven't talked about this in months because it's not really relevant for our state yet. But if both moratoria were to go away, does a landlord have to give a 30-day CARES Act notice if they're in a building that's CARES Act covered? That portion of the legislation never sunsetted, as they say in legislative speak. And so I think, yes, they would have to. Now, which is a CARES Act covered building? Any building that gets any kind of federal subsidy, even as minimal federal subsidy as there's a mortgage that is federally backed, like through Fannie Mae or Freddie Mac. That is a possibility that the landlord would have to give that 30 days notice. Now, evictions have not really been fileable for non-payment of rent in Minnesota since the pandemic began. They have been fileable in other states around the country at various windows. And in most of those other states, it's been decreed by the court, typically the Supreme Court of that state, that the CARES Act had to be complied with, at least on paper, by the landlord. They have to swear under oath that they're either not CARES Act covered or they've given the 30-day notice under the CARES Act. And so that's a possibility that might become a rule that has to be complied with.
Right. Question from Anonymous, and again, they're coming in slowly here, but we'll answer them, and I'll again put up the information about our next 2 weeks in just a moment here, so that again, these are not the rules right now. This bill is not the law yet, but could be as soon as Thursday or Friday of this week, maybe a little bit after that. So we'll be talking next Wednesday. But this question from Anonymous: do you think landlords could make arguments that some non-payment circumstances amount to a material breach or material violation if the non-payment is flagrant, unrelated to COVID-19, for fees other than rent, or for any of those?
I mean, looking at the proposed statute, I mean, it says for material violations of the lease other than non-payment of rent. So it's the one thing that the legislature is saying you can't evict for during those windows of time. So I would, if I were a landlord attorney, I wouldn't want to be making that argument. I just don't know what odds of success you really would have with that approach. I would bet heavily against that working in court for a landlord. Can they make the argument? Sure. Will they make the argument? Yes. Yes, the landlords will try that. Some landlord will try that argument. They'll say that a utility is not rent or something like that. But I would not want to be going into court on that if I were a landlord attorney. Yep, I mean, landlords have had to wait for money. They're probably going to have to wait longer. They're going to have to wait for either the money or the right to evict. It's a matter of how much longer, and specific questions about things that are going to be allowable. Adding material breach, by the way, to the list of reasons why a landlord can file an eviction. I've mentioned that this is a compromise bill. That is something that landlords and landlord groups have been demanding for months, is that they have the right to file an eviction for material breaches of the lease. I think maybe back in November, January or December of last year, seeing letters to the editor from maybe from a landlord attorney demanding that landlords be able to file evictions for material breaches. So that is a serious allowance under the statute that does not exist currently for landlords to be able to file for material breach. We've heard landlords talking about how they have non-smoking buildings and people smoking, or really disruptive tenants that are not only chasing away neighbors, but causing staff to resign in buildings. And so if they've got tenants that are that unruly, they're gonna have a new tool on the tool belt to use to be able to remove the tenant if they decide they want to go that route. The landlord will still have to prove, hey, they're violating a term of their lease, and it's a material breach of the lease. But to file an eviction for a non-payment of something, I just don't like the footing for a landlord under that statute, when the whole theory seems to be only for stuff that's non-payment of rent. It's exactly what the statute addresses.
Right. I don't see any questions right now.
Oh, you're premature there.
Yeah. Okay. Anonymous question. What would happen if a landlord filed for non-payment and claimed the tenant had not applied for rent help MN, and then the tenant didn't show for eviction court, but they really did apply for rent help MN, just weren't able to make it to court?
Well, whoever anonymous is knows their stuff. Maybe it's more than one anonymous or not, but let's sort of walk through this thought exercise for a second. And I'm going to go backwards from the last step of an eviction process. The last final step in an eviction process is that a sheriff will come out to a rental unit. This is the second time the sheriff has come, typically with a moving van. The sheriff doesn't drive the moving van, the moving company does it. Although I really believe, if you really want to dig into some statutes, that the sheriff is supposed to do the moving, if you read the statute, not a moving company. But anyhow, no sheriff's office agrees with that assessment. Anywho, the second time the sheriff comes out is the final phase of the eviction / enforcement of the writ, which is the order to the sheriff from the court ordering the tenant to go. That's the last phase of the eviction process. So what if the tenant demands that the writ be stopped? It's called a quash. No S on the front of that word. Quash, Q-U-A-S-H. The tenant tries to quash the writ, arguing that they have submitted for assistance from rent help very late in the process. Maybe the sheriff's already been once. They put the 24-hour warning on the door saying, tenant, if you're not gone in 24 hours, we have the right to come back and change the locks, remove you physically if we need to, using force, and then we'll inventory your property. Could the tenant file for rent help right up until the last minute? I mean, I guess that's possible. Writ quashes aren't simple. It's not an easy form to fill out. It's not just a one-page thing that you sign and give it to the court and hope for the best. It's a lot more complicated than that for the tenant. So I wouldn't recommend that a tenant wait until the last second to apply for rent help. But yeah, I mean, if they, and it's never a good idea to skip court where you've got a shot to win an argument. So a tenant not being able to do that, especially in our Zoom era, where the tenant might be able to show up in person, depending on where we're at in the court system, whether you're doing in court or just remote appearances, but you might be able to appear from afar. So I wouldn't encourage a tenant to roll the dice on this and wait as late as they possibly can. I would, in fact, recommend that the tenant do whatever they can to certainly warn the court, but maybe even warn the landlord, an email to the landlord or a text to the landlord. So then the landlord is put on notice that the tenant has applied, along with whatever documentation the tenant can come up with. And an ethical landlord is going to say in court when they get there, Judge, I just got this morning, but they said they've applied. I don't know if that means we have to hold off here or what. I don't want to do anything I'm not supposed to do. I'm guessing that fact pattern will play out, that it'll play out. But the fact that the statute says it's not just the filing, and we talked about this earlier, not just the filing, but or proceeding with an eviction case. An argument might be made that once the hammer comes down in the actual eviction hearing, that the eviction case is over and that the writ being issued is a different phase. I'm not sure how strong that argument is, but trying to think like a landlord attorney for a second. If I'm talking to a tenant, I'm telling them to apply as soon as they can, certainly, and to absolutely let the court know as soon as possible as well.
Right. Then a question, how is Homeline or other agencies preparing for waves of evictions, cases, waves or cliffs or other metaphors?
Yeah, what metaphor are we using these days?
Well,
we have a
there's been
favorite?
an off ramp and an on ramp and
Yeah.
I've heard the entrance to the freeway.
We're talking about the waves of evictions, though, which is not the same thing as the off ramp, on ramp.
Well, I do.
Yeah, surge, tsunami. So,
and it's also, I mean, as we've talked about today, it's not just about evictions. There is
non-renewals.
Non-renewals. Again, even though there's $670 million that is going out, it's slow, but that's why we always try to keep that in mind, that that's how you get paid, and that's why the U.S. Treasury guidance is the way it is. But
right. So how are we preparing for this, Eric? I guess we can talk about this a little bit. I think our concept of preparing for the waves of evictions started March of last year, April of last year. We started sort of theorizing how we would cope with this. Our office takes about 15,000 calls a year from tenants around the state that have questions about their rights as renters. This month that we're in currently, June, it's not over yet, but we're shaping up to be our best month ever. We've added staff and we've added hours for staff. So we've had some part-time people that we said, hey, you can go full-time until say otherwise if you wish. I know that other agencies, Volunteer Lawyers Network, Legal Aid, have added staff or tried to ramp up staff, ramp up volunteers that they're working with. One hard parts of this is knowing when it's all going to happen, which is why not is something we're advocates of, not selfishly, not how does home cope, but it's how do tenants cope is really what we're concerned about. How do courts cope is another legitimate concern. And frankly, on some levels, that's my biggest concern. There are waves of evictions. I am convinced that we're going to see a massive surge in evictions at some point. And maybe that'll be several massive surges of evictions. But predicting the size of that surge is, it's a guess. It's a guess. I've heard landlord advocates talk about, I'll guarantee that will not be a surge. I just don't know if I can make that promise. I don't believe that that's going to be the case. I can't promise you that it's not going to be the case. But when the eviction court doors open again, is Hennepin County's housing court going to be just a ghost town and empty and nobody's showing up? I just can't believe that. I have to believe that whether it's electronically or in person, there's going to be a line of landlords that decide to go file the evictions. Again, if I'm a business person and a landlord, I'm trying to get paid. I'm in the business of collecting rent. I'm not in the eviction business. There are going to be some landlords that when the phase is open, though, they're going to say, you know what, I've done the business analysis. This tenant is too risky. I don't think they're ever going to be eligible, so I'm going to go after them and I'm going to file the eviction, cut my losses. And that's going to be a good number of people. And the real reason I think there's going to be a surge is once a landlord decides to pull the trigger on an eviction, why would they wait? There's no incentive for them to wait at that point. Once they've decided to file, they're going to file when the doors are open. And so that's why I think there's going to be these surges in time where we get, I don't know, I don't think it's unrealistic to see at some point getting 10,000 evictions filed in a week in Minnesota, where normally it's 15 to 20,000 in a year filed in Minnesota, because all these bottled up evictions, once the doors open, landlords are going to say, I'm done waiting, so I'm going to go file. The court system just isn't set up for that, for dealing with 10,000 evictions in a week in this state. Not if they want to have any kind of meaningful due process.
Yeah, and as we had on Leah and Andrea from our office a number of months ago, who pulled the data on this, and we are at, for the first year from late March of last year through late March of this year, at about 8% of the normal year's worth of eviction filings. So, I mean, there's definitely some interventions that have taken place to prepare, whether or not this bill that might get passed into law prevents. I mean, it is going to prevent. It's going to prevent some cases, and as is the Rent Help MN funding, but there are going to be increases, and so. And on that point, social worker asking a question: can a non-lawyer service provider like the social worker attend eviction court? What if social worker shows but the tenant does not? Can they request that the case be postponed or confirm that Rent Help MN has been applied for?
So there's a law that talks about in Minnesota that a lay advocate is the phrasing they use, can represent not just a tenant, but a landlord in court, as long as they don't pretend to be a lawyer or charge attorney's fees if there's not a jury trial or if it's not at the appellate level. There's some limitations on that. But ideally, the tenant is there along with the social worker, and the social worker says, hey, my client is really nervous about speaking, and so they've asked me to say this brief thing. And so that's possible on some levels. If the tenant isn't there, it's going to be a lot more difficult to do. Can the tenant or the social worker request a delay to confirm that rent help has been applied for? Not likely to get a delay for that reason. I mean, if the social worker were to show up and say, hey, I helped them apply for rent help, I saw they filled out the application and I've seen the page online, they've applied, that would be very different than saying, I want some more time to be able to prove it. Hard to know the second half of that question. Can the request be postponed for rent help purposes? The landlord might be most interested in delaying the case because they want to get paid. And so they might agree to that, which can always happen. If a landlord agrees to postpone or delay a case, the court's never going to step in the way that, if both sides want to do it. But if the tenant's social worker unilaterally shows up saying, maybe they applied for rent help, I'm not sure, and I want more time to be able to prove that they did, the judge is likely to say no, I think, for that specific set of facts. But again, we're very what's going to happen in the future trying to analyze that here. You're muted, Eric.
It doesn't, can you hear me now? Yep. All right, it doesn't stop a social worker, a provider in some way to help, obviously, with the process of applying and then to try to notify the landlord. I mean, again, this bill is supposed to create this, what does create this 15-day notice requirement. So tenants will be getting notified, but if you're working with individual tenants already, maybe you've already been spending a lot of time helping them apply for rent help MN, but they are going to get this notice that says how much is past due. So that could help with the application process, and then demonstrating that there has been an application. So our understanding, again, we're not experts in rent help MN, but there is apparently a way to go in and see that application is pending, online, and that I think maybe you can now call 211 and get that information about a pending application.
Yeah, just printing that screen might, I mean, from what's the best use of the social worker's time kind of question. Trying to help the tenant apply for rent help, which might be a somewhat difficult process for many people to navigate. So trying to help them apply and helping them obtain proof that they've applied is probably a much better use of your time than hoping to go to court and make some sort of winning legal argument. Sending the tenant with that one printout might be the key thing. And as Eric just mentioned, texting that or emailing that to the landlord in advance saying, hey, I know you want to get paid. They've applied. I help them get into the system. That might be the most important step you'd take.
Yeah, and then, I mean, also related to that in a previous question, organizations like Homeline and legal aid offices throughout the state are, have been preparing for this. And so that's going to be another option, is to try to get them to somebody to get advice to them, which is our contact info I can put up, but getting them to a legal aid office who in some cases, or many cases, depending on where you are in the state, is going to probably try to defend as many eligible tenants under their guidelines. One last question here. I've heard from landlords who want to sell their homes and want to get the tenant out before going forward with selling. Would these landlords have to wait until the 105-day mark, assuming there are no material breaches and the tenant's current on rent?
I think that's right. That the landlord would have to wait for the 105-day mark in order to be able to give a notice to vacate for that reason. Yes, that's my best guess.
Okay, well, I think that concludes the questions. Again, I put in the chat the information about registering for the next 2 weeks, Wednesday, June 30th at 1:30 in the afternoon, and Wednesday, July 7th at 1:30 in the afternoon. We'll be doing at least 2 more sessions, and probably more going into July and August as things play out with this. And again, next week we'll be joined again with Mike, but also Andrea Palumbo and Rachel Sterling, 2 housing attorneys on our staff, and we'll probably be going through a lot of details about the CDC and the new state rule if it's in an application. Then with that, I'm gonna end the session, I think, unless there's anything else.
All right, thanks, Eric.
Thank you.